Calls the case. Red Line Apartments versus Harvey Hudson.
I also want to point out that it's Miss Hall's birthday tomorrow, so maybe
Is
a
it?
little bit of a tough time.
Happy birthday.
I just had to do
the beat 29 again.
Yes.
All right.
I remember those.
How you doing, sir?
I'm good. Okay.
All right. Where are we on this?
Your Honor, what, I don't know if Ann probably remembers this. What happened to Mr. Hudson was here last week and he was on the court Zoom.
Yes.
And it went down and we thought he left. And so you allowed me to enter a default. Then shortly thereafter, he wrote an explanation. So
I never left.
Well, he never left, but
that's why we're reset to without any. Yeah.
So his ballot, I asked him today, I said, so what's your plan? He just wants to get some time so he can move out.
Got it.
So what I suggested was giving him till the 26th, which would be basically 10 days from today. Actually be the day after Memorial Day. And he said, that's fine. He can be out by then.
Then you, sir?
Yes, sir. Yes.
All right. You can take your hands out of your pocket.
I'm sorry. It is
Okay.
I'm sorry.
So, got a judgment here.
Or do you just want to leave that one in? Just, I'll do it however the court wants to do it.
In terms of what?
You already got a judgment in this case.
Oh, I see what you're saying. Okay. Yeah, I'll just leave the judgment, extend the writ date out. So you understand, sir, that despite whatever's going on, I'm going to leave the judgment that they took in place.
Yes.
Okay.
Okay.
But I'm going to extend the writ date in this case to the 26th.
Okay.
Okay. Instead of whatever it was on the 18th or something like that. So I'll extend your writ date to May 26, 2026.
So just make sure you're out by then.
Yes. Okay.
Okay. All right.
Thank you, sir.
Yep. Sorry the internet went down on you.
No problem. No problem. Thank you.
No. All right.
Thank you.
Take care.
Your Honor, that's all for me today. Have a good weekend.
Do the same, sir. Hamptons of Clover Lane versus Carlos McMahon.
Good afternoon, Your Honor. Brad Decker for plaintiff.
Your name, sir?
Oh.
All right. Where are we on this case?
Right now, what I'm showing is $43.98 and 34 cents, including court cost of $175.
At 43.98.
Yep, $43.98 34 cents, Judge.
All right, sir.
Thank you, Your Honor. I was trying to pay $2,500. I've been trying to pay $2,500 since Monday to try to get this because this is from April's rent, and then now they also tacked on May rent as well.
Right.
And so I was trying to pay the $2,500 to get April off, and then try to move out by the end of the month, and then also pay by the 30th for May. I'll have it all paid
So you're
off.
trying to move.
Yes, Your Honor.
All right.
Because currently, right now, I'm on monthly.
Right. Because you said you were going to pay $2,000 by today, but you're going to try to pay $2,500 by today.
Yes, Your Honor.
All right. So here's what I'll do. I'll find no tribal issue. You're not disputing the amount. So indicate that, and so I'll grant the judgment for the 43.98.34 with the writ to issue, and then so listen real close to what I'm saying. Writ to issue the 25th. Okay. However, if defendant pays $2,500 by the 15th of May today, then the writ's extended to May 1st, actually June 1. Writ. You understand that, sir?
So there's no way for me to get this dismissed.
Not unless you were going to get everything paid or moved out.
Understand?
That would be the only way that happens. So if you get the $2,500 paid, then you're at June 1. And then just adding that to the form. All right. Thanks, John. Redwood Superior Township versus China Green.
I think I've played it.
Hello, your name?
Angry.
All right. And where are we on her case?
We did receive a $3,300 payment that has been processed now, so she's at $1,953.88, including $175 of court cost. And I do want to put it on the record, there was an issue with my client accepting whips. We will accept payment by whips at this point for the remaining balance.
Whips.
The walk-in payment system where you can go to like Walmart or Kroger and pay for it. I've been trying to pay since Tuesday.
And they wouldn't take it. So you're going to get this paid. When are you?
Oh.
When are you going to have this paid by?
I can go after work today and pay it.
So here's what I'm going to do. Since they wouldn't take her money, I don't understand why people won't take money. I'm going to adjourn this out 1 week to the 22nd, 2026 at 2 p.m. If everything's paid, it's going to be just. All right? Sound good? All right, screen, you take care. Set it for that mile.
I like the balance. Thank you, Judge.
Court calls case of Lori Anderson versus Armani Lawns. Here's, I'm sorry. Did we get the email to the court so that counsel's aware? It says, hi, this is Irani Lyman. My hearing is got rescheduled until today at 2 p.m. I'm in the hospital and will not be able to make it. I want to see if I can get another agenda, please. I will say, if counsel's not aware, I adjourned it to the last hearing because she had sent in medical indicating that she was in the hospital at that time.
Your Honor, my client is called the hospital and Miss Lyman was released on Sunday. And then here's the thing.
Wouldn't have given her that information.
Knowing Miss Lyman's the information.
Oh God, really? Exactly. You use somebody's information that you got for other purposes for the purpose of checking whether or not they were in the hospital. That is absolutely deplorable.
Still.
Inexcusable. Absolute excusable. Well, not going to benefit you today. I'm going to adjourn it. I'm not. I can't even believe he did that. Adjourn this to May 29th, 2026 at 3 p.m. Thank you.
Thank you. I've got one.
Apologize for interrupting. The 29th, it should be
At noon.
went to me.
Okay, yes, I went to.
Well, we want to go there. So that's going to be at noon?
At noon.
At,
You have Maple Heights?
I do.
Maple Heights Apartments versus Aaron Simpson. No relation.
Attorney J. Big on behalf of plaintiff.
Aaron Simpson? Check in. You like to proceed?
Yes,
And raise your right hand to be sworn.
I will.
solemnly swear or affirm testimony you're about to give will be truth, whole truth, nothing but the truth, so help you God.
Yes.
Go ahead, sir.
All right. This is an action for possession only. Rent to retain $589 even. Court costs of $171.18. A total of $760.18. My knowledge, defendant is not a minor, not incompetent, not in the military. To my knowledge, paragraph 7 of the complaint, the habitability section still holds true. I do have a proposed judgment. Sign it, and may I approach, Your Honor?
Judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested with the writ issue in 10 days.
Thank you.
Is that it? All right. Have a good week.
All right. Thank you.
Mr. Katz, you there? Or?
Your Honor, do you hear me?
Yes, we can hear you now, sir.
Sorry about that. My Bluetooth kicked off.
Okay. No, not a problem. All right. We're on the Martin matter.
Yes. Good afternoon, Your Honor. Sidney Katz, I'm a plaintiff.
All right. And how much do you have owing at this time?
Your Honor, this is a non-payment rent possession case. There's currently a balance due, including costs of $1,507, 1507.
All right. That last week we were here. I thought you were going to pay 500.
I was able to turn in 410 yesterday. I ran into some car troubles. That's why it wasn't the 500 on the Friday like we had spoken. But as of the remaining balance, I have 2 more checks coming in as of next week because I just started another job.
So when do your checks come in?
On the 21st.
Those are 2 checks coming in?
Yes, sir.
So you have it paid by the 21st?
Yes, sir.
I'm going to find that no tribal issue after hearing. I'm going to grant a judgment to the plaintiff by default for the full amount of the 1507 with the writ to issue. You can have it by the 26th. Okay?
Yes, sir.
So you'll have until that time. Okay.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you. Willow Ridge Apartments versus Azaria. Is it Dameron? Dameron? Karina Dameron.
Yes, I'm here.
Okay. And what is the claim in this case today?
Your Honor, this is a non-payment rent possession case. I did actually discuss this with Ms. Dameron. There's currently a balance due, including costs of $3,065. That's 3065. And we would give Ms. Dameron until the 29th.
All right. Ma'am, is that correct?
Yes.
All right. I'll grant a judgment to the plaintiff by consent. $3,065. That is payable by the 29th, writ dates extended to May 29th, 2026.
Thank you, Your Honor.
That will be by consent. Ms. Dameron,
Yes.
you have 3 business days from my signing of the judgment in this case to think about it. If you believe that there's some legal reason, some right you didn't assert, some confusion on your part or some mistake on your part, you could file a motion with the court within those 3 business days. Doesn't mean that I'd grant it. However, you have that time frame. You understand that?
I do.
All right. Very good. Thank you.
Thank you so much, Your Honor.
You're welcome.
Bye.
Willow Ridge Apartments versus Hassan Abu.
Good afternoon, Your Honor.
Good afternoon. Last name?
Abuado.
That's what I was going to say. All right. What do we have in this case, Mr. Katz? I'm losing. I can't hear you, Mr. Katz. You're really in and out. I don't know if he can hear me. Can you send a message to him that he's gone? Nope, he's there.
Yeah, he dropped.
He dropped. Okay, I'm going to pass it for a second, sir. Okay, we'll get you back up. Scott Gordon versus Michelle Mathis.
Scott Gordon here. This is another Deborah Vart. Sides. Step on this side.
All right. Your name? You're Scott Gordon.
Yes, this is my significant other, Deborah Vard, Michelle's mother.
All right. Her name?
Michelle Mathis.
All right. And this is a termination case. Where are we on this, folks?
I have prepared something if you'd like to read it.
What is it?
It's just what I'm going to say here. In 2020, Michelle had to move out of her boyfriend's house and she was welcome in our home. Excuse me? Oh, thank you. And enrolled her daughter.
Okay. Let me.
Okay.
Is there a lease?
No.
All right. And how long have you been residing in the premises?
2.5. And all I'm asking, 2.5 years,
Okay.
30 more days until my daughter's out of high school for the year. I didn't want to move her out of Saline, and she's in track and sport. I spoke with this to Deborah, track, and she was in cheerleading. So I didn't want to take her out. And
Okay.
so she's out June 4th.
What year? You need to take your hands out of your back.
Oh, I'm sorry.
Is she?
15.
Hold on.
9th grade.
She's in 9th grade.
Yes.
Okay. And so, and you're looking for just to be able to finish the year before moving. Is that?
Yes, correct. Yeah.
Your Honor, when she moved in 2.5 years ago, free room and board, we just asked that she give us some help and help do the some chores around the house. That never happened. And we had many discussions about it.
Okay. So all of that seems to me to be water under the bridge. I've got a 15-year-old that's trying to make it through the rest of the school year. So she's just asking, she says she'll move, right?
Yes.
She's just trying to get her daughter, was it?
Yes.
Trying to get her daughter through the school year.
I understand. That's why we waited till May of last year to ask her to move. And that didn't happen.
So you want me, when is her last day?
June 4th, which is 3 weeks.
No, I know it.
Okay. I'm sorry.
Calendar myself here. So you want me to kick her out before June 4th?
Actually, we tried to get her removed last year.
I'm not asking what you tried to do. What you're asking me to do right now is to kick her and her daughter out while her daughter's trying to finish up 9th grade.
Her daughter's welcome to stay.
How am I going to have a 15-year-old stay? And what the heck? I don't. In what world do you think that's right?
She stayed with us for many times.
So daughter's welcome to stay, but mom's not.
Mm-hmm.
Why?
All we asked her mom was to help chores around the house, and she flat out refused for 2.5.
Okay. I hear you. So what you want to do is you want to punish mom, ultimately punish daughter because she won't have her mom there, right? And that's the right thing to do?
At this point.
Okay, look, here's what we're going to do. You may be entitled to a judgment at some point, but not today. So here's what's going to happen. I'm going to adjourn this matter out. June 5th, 2026. What time?
We don't have it. I'm so sorry.
We don't have the 5th?
No.
So I'd have to go another week out?
Yes.
Gosh, she'll be a week out of high school. Horrible things will happen, apparently. I'll set it for June 5th, special time. What time? 1 o'clock. So I'll set this one special time, June 5th, 2026, 1 p.m.
In this courtroom moment, the judge balances firmness with compassion during a tense housing dispute. What begins with lighthearted birthday comments quickly shifts into a serious discussion about an eviction case involving Mr. Hudson. After technical issues during a previous Zoom hearing caused confusion and nearly resulted in a default judgment, the court revisits the situation to ensure fairness and clarity. The defendant explains that he simply needs more time to move out, and the court carefully considers that request. Rather than escalating the conflict, The judge grants a short extension until May 26, 2026, while also keeping the original judgment in place. The exchange highlights how courtroom decisions often involve both legal enforcement and practical human circumstances. One of the most notable moments comes when the judge directly confirms that the defendant understands the consequences if he fails to leave by the new deadline. The respectful tone from both sides keeps the hearing calm, professional, and surprisingly cooperative despite the pressure surrounding eviction proceedings. This hearing serves as a reminder that even routine civil cases can carry major personal consequences, and that clear communication inside the courtroom can dramatically affect the outcome.